Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 63. This is a special day. Indeed, it's an auspicious occasion because today is my 51st birthday. Yes, I know it's hard to imagine that someone who sounds as youthful as I do is actually 51. I did try to persuade Chris Fisher, whose voice you hear at the very start of this podcast, to replace his standard announcement with a rendition of Happy Birthday. Curiously enough, no can do. Anyway, in this podcast we'll be looking at three recent cases. The first is a Court of Appeal decision which has attracted a fair amount of public attention. It's a case about whether a bus company must have a policy to compel non-disabled passengers to vacate a wheelchair space if a wheelchair user required it. And whilst it's not strictly an employment law case, it does look closely at the duty to make reasonable adjustments which can be applied in an employment context. The second case is an EAT judgment about whether an employer had correctly treated a dismissal as being for redundancy. A redundancy law can still cause difficulties, and the consequences of the employer here, when it was found to have, in my terms, miscategorised the dismissal, were unfortunate. Thirdly, we have the latest in a continuing series of cases exploring the jurisdictional scope of employment tribunals and their ability to hear cases from employees who are working abroad at the time of dismissal. So, before going any further, though, I'd like to make two quick parish announcements. First, I would really recommend that you listen to the special guest podcast with Claire Nicolau of Game Retail, talking about the recent social media case with which she was involved, Game Retail and Laws. Social media issues affect all employers, and Claire was involved in the first reported case to go to the Employment Appeal Tribunal on the appropriate response by an employer to an employee accused of posting offensive comments on what the employee considered to be his personal Twitter account. Case is a really good illustration of the challenges faced by an employer, and Claire makes some really interesting points during our discussion. Secondly, stay tuned at the end of the podcast because we're going to have some exciting news about a further rollout of this podcast. I promise we'll not take to calling it The View 2.0. So, first case, First Group plc and Doug Pawley. This is a Court of Appeal decision which has received, as I say, a fair amount of public attention. The case involved the policy adopted by First Group buses in relation to wheelchair passengers. Key questions were whether First Group's policy was indirectly discriminatory to wheelchair users and whether First Group were required to go further than they had done to discharge their duty to make reasonable adjustments for wheelchair users. One of the things that the case does illustrate is quite how difficult it can be for First Group in this case, and employers in other cases, where an employer is trying to reconcile two legitimate interests, both of which are worthy of protection. Here, it was, in part, the balance between parents with pushchairs and young children, on the one hand, and wheelchair users, both of which require a degree of understanding and latitude. In summary, the Equality Act 2010 prohibits disability discrimination, direct or indirect, and imposes a positive obligation on service providers to make reasonable adjustments for disabled persons. If a service provider has a provision, criterion or practice, PCP, which puts a disabled person at a disadvantage in comparison with a non-disabled person, then the service provider should take reasonable steps to avoid that disadvantage. Pausing there, it's important to mention it's common ground in this case that Mr. Pawley was disabled for the purpose of the Equality Act, and his particular disability required him to use a wheelchair. Also, First Group is a service provider, and as such it's obliged to adhere to the provisions of the Equality Act, and these are very similar to the obligations imposed on employers. Facts of the case are also relatively straightforward. Mr. Pawley, a wheelchair user, arrived at a bus station in Wetherby, intending to catch a bus to Leeds. The bus was operated by First Group. The bus in question did have, as legally required, a wheelchair space, but it was occupied by a woman in a pushchair with a sleeping child in it. The driver asked the woman to move and fold down the pushchair so that Mr. Pawley could board. However, the woman refused because the pushchair apparently would not fold down. Consequently, Mr. Pawley had to wait for the next bus, and he subsequently missed his train to Leeds. Mr. Pawley sued First Group for unlawful discrimination on the grounds of disability. His case was successful at the county court, and he got £5,500 damages. First Group then appealed against this decision, hence the Court of Appeal decision. First Group's policy in place at the time was as follows. 1. Buses must have a space for wheelchair users. 2. Bus drivers must ask anyone already occupying the wheelchair space to move to another part of the bus in the event that a wheelchair user required that space. But 3. Drivers were not required to compel passengers to move out of the wheelchair space or vacate the bus, so first come, first served, in effect. The result of this policy was that if passengers were in place already when the wheelchair user arrived but were unable or unwilling to move, wheelchair users would have to wait for the next bus. The policy is referred to in the judgment as the request not require policy. So, on the facts of the case, the bus driver had complied with First Group's policy as he had requested the woman to vacate the space, but he didn't require her to do so after she refused. It's important to emphasise that First Group's policy was in line with legal obligations and government guidance issued at the time for service providers. There was no freestanding specific legal obligation on bus companies to have a policy that required the bus driver to compel passengers to vacate the wheelchair space. So the question was whether the Equality Act provisions dealing with disability discrimination, in effect, required the driver to go further and compel the space to be vacated. The key questions before the county court then were 1. Whether First Group's request not require policy was a PCP. 2. Whether Mr. Pawley suffered a substantial disadvantage when compared to a non-wheelchair user as a result of this policy, and 3. Whether First Group should have made any additional reasonable adjustments to their policy for wheelchair users. County Court found that First Group's policy did amount to a PCP. Moreover, they found that the policy did place him at a substantial disadvantage when compared with non-wheelchair bound bus passengers. Finally, and crucially, the County Court had held that the First Group ought to have made a reasonable adjustment to their policy to require non-wheelchair bound passengers to move for wheelchair users. The judge found that it would have been a reasonable adjustment to have altered the conditions of carriage issued by the bus company so that they could require any non-disabled passenger occupying a wheelchair space to move from it if the wheelchair user needed it, coupled with an enforcement policy which meant that such individuals would be required to leave the bus if they failed to comply with the requirement to move. The Court of Appeal did not agree. The Court of Appeal helpfully started by recounting key factors which should be taken into account when deciding whether a service provider should make reasonable adjustments. And these include 1. How practical is it for the service provider to make such reasonable adjustments? 2. What's the financial cost of making the adjustment? 3. The extent of any disruption that making the adjustment would cause to the service provider. And 4. A consideration of the service provider's own financial resources. The Court of Appeal made it clear that in determining whether something is a reasonable adjustment, this is going to involve a balance between, on the one hand, the ideal position of removing all and any disadvantage for disabled persons, and, on the other hand, the costs and the difficulty of making the suggested adjustment. In essence, the Court of Appeal pointed out the policy required by the County Court had, in my terms, numerous problems with it. The Court of Appeal pointed out the difficulty of the bus company and or the driver in enforcing the removal of a passenger. It would expose the driver to the risk of committing common law battery. It would also increase materially the real risk of confrontation, perhaps between passengers or between passengers and the bus driver. Also, it was accepted in argument that such a policy could have very unfair consequences. What about a mother taking a child to a hospital appointment? What about a blind person whose guide dog was occupying wheelchair space, etc., etc.? It would also then be unfair to require the driver to adjudicate between competing claims to the wheelchair space. In essence, the absolute policy suggested by the County Court was not a reasonable adjustment. The fact that some passengers, although on the evidence rarely, act selfishly and irresponsibly and refuse to move is not a sufficient reason for imposing on the bus companies a legal responsibility for a situation which is not of their making and which they are not in a position to prevent. Quote, "In the present state of the law, something must still be left to the good sense and conscience of individuals." Unquote. And the court accepted. As a result of their finding, wheelchair users will occasionally be prevented from using the bus, and this will sometimes not be for a justifiable reason. However, they felt unable to impose a legal responsibility on bus companies for a situation they could not prevent in the first place. Interestingly, one factor in this case that seemed to have some weight was the infrequency of the issue at hand. Perhaps the court would have felt more compelled if they'd found that a reasonable adjustment could have been made because there was evidence to show the unfairness for wheelchair users was a frequent occurrence. I think the case is a useful one, even though it's not in the employment setting, as it sheds light on the parameters of the reasonable adjustments obligation. In light of this case, it's clear that reasonable adjustments must be practicable, and it is sometimes the case that adjustments will not be considered reasonable. The emphasis is on making reasonable adjustments, not just any adjustments that are potentially available. And so whilst the Equality Act does put an obligation on employers to make reasonable adjustments for disabled persons, there will still be the need for regard to be had to other competing interests in evaluating the extent to which an adjustment is reasonable. So that's the case of First Group plc and Doug Pawley. So the second case is Exol Lubricants Limited and Birch and another. And this is an EAT decision on an unfair dismissal claim. And the case turned on the label applied by the employer to the dismissal, which in turn affected the process it followed. The redundancy legislation has been around in one form or other since, I think, the Redundancy Payments Act 1965, 1 year after I was born. But it's still capable of catching out the unwary employer, which is what seems to have happened here. This is an EAT decision regarding, in effect, whether the employees had lawfully been made redundant in accordance with the provisions of the Employment Rights Act, and it centres on whether the employer, Exol, had, quote, ceased to carry on business in the place where the employees were employed, unquote, which is the relevant part of the redundancy legislation that Exol were relying on. The facts of the case were that the claimants, Mr. Birch and Mr. Perrin, were employed as delivery lorry drivers by Exol. The claimants lived in Manchester, but Exol's depot was in Wednesbury. The contracts of employment stated their place of work was Wednesbury. However, the cost of commuting from Manchester to Wednesbury every day in their own vehicles was too much for the claimants. So, as a compromise, Exol agreed that the claimants could park their delivery lorries in a secure car park in Stockport, which was near their homes. This was beneficial for the claimants as their journey from Stockport to Wednesbury, and back each day, was treated as part of their working day, and they were paid for this travel time. Both sides acknowledged this arrangement had become a term of the claimants' employment contracts. But sometime after it had started, Exol stated it could no longer afford to pay for the parking in Stockport, and it gave notice to the claimants to terminate this arrangement. Exol hoped to be able to reach an agreement with the claimants to this change, but they were unable to do so. The result was that Exol dismissed the claimants, and the reason given was redundancy, and the claimants got 7 weeks in lieu of notice. Pausing here, it's worth pointing out the initial reason given by Exol for the proposed dismissal in a letter to the claimants was some other substantial reason, rather than redundancy. However, the parties continued to negotiate after that letter had been sent, and the claimants put forward a number of other options, which were not considered as suitable by Exol. Following this, there were grievances, and then there was a dismissal, which was suspended, pending the outcome of the grievance process. However, at the end of the day, Exol wrote a letter to the claimants, and the reason given for the termination was redundancy. And as I'm going to explain in a second, that was crucial. And there never was an explanation as to why the reason had changed from some other substantial reason to redundancy. But in terms of legal background, Section 139 of the Employment Rights Act sets out that an employee will be taken to be dismissed by reason of redundancy if the dismissal is wholly or mainly attributable to the fact that the employer has ceased to carry on the business for the purpose for which the employee was employed by him, or to carry on that business in the place where the employee was so employed. And that's the phrase, in the place where the employee was so employed, that's critical. So in this case, Exol had to prove they no longer carried on the business in the place where Mr. Birch and Mr. Perrin worked. Exol's assertion, or the basis for saying this was a redundancy, was on the basis that the claimant's place of work was Stockport rather than Wednesbury. Stockport was where the lorries were parked. The lorries were no longer going to be stored or parked there overnight. Therefore, Exol tried to rely on Section 139 to say that they had ceased business in the place where Mr. Birch and Mr. Perrin were employed. Conversely, in Wednesbury, there was no suggestion that there had been a diminution of work or anything of that nature, so Exol would not have been able to argue that there was a redundancy situation in Wednesbury. That was why it was important for them to say that the redundancy situation arose in Stockport, which in turn led to the question, were the employees employed to work at Wednesbury or Stockport? Claimants brought a claim to the Employment Tribunal for unfair dismissal and breach of contract along with a number of other claims. Tribunal found in favour of the claimants for unfair dismissal, held their place of work was not Stockport but was Wednesbury. Exol had clearly not ceased work in Wednesbury, and this was evidenced by the fact that, following their dismissal, they were replaced in Wednesbury by 2 other lorry drivers. So there was no reduction in headcount. Tribunal also held the claimants were owed damages for breach of contract, which I don't need to say any more about. Tribunal noted that the Stockport parking arrangement had become an implied term of the claimant's employment contracts, and that Exol had needed the express consent of the claimants in order to change these contracts. As such, Exol's hands were tied because the claimants refused their consent. They were left with no option but to unilaterally change the agreement and then ultimately terminate it. Well, Exol appealed the finding of unfair dismissal, but the EAT dismissed the appeal, upheld the finding of unfair dismissal. The EAT considered several cases on Section 139 and what was meant by the phrase, quote, the place where the employee was employed, unquote. In the context of an employee who has no fixed place where he carries out his duties, such as a delivery driver in this case, the EAT found that it was necessary to have regard to two key factors. 1. Terms of employment contract, and 2. Any connection the employee may have to the depot or head office of the employer. Here, as I mentioned earlier, the employee's place of work under the contract was stated to be Wednesbury, and both employees had close connection with the Wednesbury depot. They reported to it on a daily basis, they loaded their lorries there every day, and this is where their instructions came from. All in all, it's not difficult to see that this is where they were deemed to be employed for the purposes of Section 139. The only connection with Stockport was this is where they parked their lorries and where their day started and finished. But ultimately, it didn't really matter where their lorries were parked, they were required to attend Wednesbury every day. The EAT usually set out general factors that should be taken into account when determining where an employee's place of work is, including, generally, it's a place which will require some attendance on a regular basis, and it'll be a place where goods are collected or instructions are received. Also, the EAT judge, I think it's fair to say, intimated that had the dismissal been put on the basis it was some other substantial reason, then potentially other considerations would have come into play. However, as Exol had sought to rely on redundancy as the reason for dismissal in this case, this was irrelevant. It's fair to say the employers had, very late in the day at the tribunal hearing, tried to amend their notice of appearance to assert there was a dismissal by reason of, quote, some other substantial reason. And the EAT records that the tribunal judge had been clearly, quote, nettled, unquote, by this attempt, and it had been rejected. So, on that basis, the employers had failed to discharge the burden of proof on them to show the reason for dismissal, therefore the unfair dismissal claim was successful, and there was no Polkey reduction. So the case serves as a useful warning for employers who may operate an informal arrangement with certain employees, such as starting work from a place outside the office. In the light of this case, it's possible that employers may be running the risk of such an arrangement being deemed to be a term of the contract, and therefore no longer something which the employer can change unilaterally. I also think the case is helpful in outlining the type of factors that an employment tribunal will consider when deciding whether an employer has ceased to carry out its business in the employee's place of work. This will be particularly useful in cases where the employees do not necessarily have a fixed place of work, such as a travelling salesperson or perhaps a consultant who spends his or her time at different locations. But finally, and I think what is very striking when you read the EAT decision, is the extent to which the legal arguments seem entirely divorced from the factual points. As sometimes this happens, the court's decision shines a light retrospectively on matters which were not clear to the parties before, or indeed during the hearing. But the essential position of the employer here was that it could no longer afford to continue paying the additional costs of the lorries and their private parking arrangements at Stockport. Certainly by the time the case has reached the EAT, this has been completely lost to view in the legal arguments, and instead there's a debate about where the employee's place of work was. And perhaps this is what led the EAT to comment that if the employer had advanced some other substantial reason as being the statutory reason for dismissal, the case might have taken a different turn. From our point of view, whether there are reorganisations or contractual changes, it's often prudent to plead the dismissal in the alternative, whether it's primarily redundancy, but in the alternative some other substantial reason, or vice versa. Sometimes the concern with that is that the employees themselves will not understand if a dismissal connected with a change in terms and conditions is not treated as a redundancy. We've certainly seen that. We've got around this in the past by saying to employees in the communications ahead of the dismissal that although technically it might be arguable that the dismissal is for some other substantial reason rather than a redundancy dismissal, it will be treated as if it were a redundancy dismissal for the purpose of calculating any severance payment and indeed the same safeguards that would apply for consultation process, etc., as it would be if it was an orthodox redundancy. In our experience, that's more than enough usually to ensure the employees don't get confused or worried about the process to be followed, and the employer stays on the right side of the line. So that's the case of Exol Lubricants Limited and Birch and another. Final case, Mrs. Lodge and Dignity and Choice in Dying and Compassion in Dying, two separate respondents. This is an EAT decision considering the territorial reach of the rights contained in the Employment Rights Act. By way of a quick background, as you will be aware, Section 196 of the ERA contained provisions regarding the territorial reach of the Employment Tribunal when looking at cases brought under the Employment Rights Act. However, that section was repealed without replacement in 1999, and ever since, tribunals have been left with guidance provided and developed by case law on the scope of their jurisdiction. And often, this is a crucial battleground for claims. If an employee can establish the jurisdiction is in the English tribunal system, they may be in a very strong position, particularly if the employer handled the matter on the basis that the individual had no English statutory claims. And the basic principles adopted from case law are: 1. The Employment Tribunal must ask whether Parliament can reasonably be taken to have intended the claimant should have the right to bring his or her claim before the tribunal, and 2. In the case of a truly expatriate employee who works and lives abroad, there must be an especially strong connection with Great Britain and with British employment law, both. Background facts of the case here were that Mrs. Lodge sought to bring a claim for unfair dismissal and a whistleblowing claim in the London Central Employment Tribunal. She was employed jointly by the defendants. She's an Australian citizen, but at the time her employment started, she lived and worked for the defendants in London. A few months after the start of her employment, Mrs. Lodge and her family had decided to move back to Melbourne for family reasons. She asked the defendants if she could continue in her role as head of finance, but working remotely from Australia. They agreed, and Mrs. Lodge continued as head of finance, working remotely from her home in Melbourne for over 4 years. There was no dispute between the parties in respect to some of the features of this arrangement, including Mrs. Lodge would deal with her own tax affairs in Australia, would join the Australian pension scheme. Also, it was agreed she would not pay tax or NI in the UK. As part of the arrangement, Mrs. Lodge returned to London 3 times a year, assist the annual audit, attend the AGM, and an annual away day. Mrs. Lodge's employment contract was expressly governed by the laws of England and Wales, and in the contract itself the parties submitted to the exclusive jurisdiction of the English courts. The events which led to the tribunal claim were she raised a grievance under the grievance procedure. This was heard in London, as was her appeal against the decision. She made submissions by email from Australia. Following the unsuccessful grievance, she was informed that she would be subjected to disciplinary action. Subsequently, she resigned and claimed constructive unfair dismissal. Pausing here, it's worth highlighting the merits of her claim are not the subject of the AT decision, only the question of whether the Employment Tribunal had the jurisdiction to hear her claim. The case continues, as they say. The tribunal found that Mrs. Lodge fell into the category of employees who needed to show an especially strong connection with Great Britain and British employment law. The Employment Tribunal found that she had failed to establish such a strong connection. This was despite the fact that her employment was clearly connected to Great Britain by virtue of the fact that she did all her work for the defendants, who were solely based in London, and the employment contract was governed by English law. However, the Employment Tribunal found that it was not Parliament's intention for Australian citizens who paid Australian taxes and pensions and lived and worked in Australia to be able to bring claims under the Employment Rights Act in an Employment Tribunal in England and Wales. She appealed. The EAT disagreed with the findings of the tribunal. The EAT decided that, as all of the work done by Mrs. Lodge was for the benefit of the defendant's London operation, and as her contract was governed by English law, she could bring her claim in the Employment Tribunal. The EAT also held that it was a relevant factor that Mrs. Lodge was unable to bring her claim in Australia, and it was relevant that the claimant's grievance was handled in London. Therefore, Mrs. Lodge did not lose her right to bring a claim under the Employment Rights Act. The appeal was allowed, and the tribunal's decision was reversed. Now, my personal view is I think the outcome of the decision is, when you've read the decision, relatively unsurprising. Mrs. Lodge clearly had a close connection with the UK. We've talked about her returning to work, all her work was done for the operation in the UK, etc. However, the case does highlight a number of factors which it would be useful to consider in a case that was less clear-cut, including the governing law of the contract. Where was the disciplinary or grievance procedures being carried out, and whether the work was being carried out solely for the purposes of an office in England and Wales. But the case overall is a useful indicator for employers of what will be considered when determining the question of territorial reach and the facts of any case, and, of course, the cases are going to be very fact-specific. But I think there are 2 aspects to this case which are worth commenting on further. First, when arrangements have been set up, and employers are looking at terminating them or facing an employee alleging constructive dismissal, it's obviously helpful to have the guidance of this case. Some employment lawyers might have considered it relevant the employee chose to work in Australia for family reasons, and it was nothing to do with the business asking them to go and work in Australia. Similarly, the fact that she was paying tax in Australia and had clearly returned to live in Australia rather than it being a temporary posting or anything of that nature would also be thought to be facts against jurisdiction being given to the English Employment Tribunal system. To that extent, this case disagrees, and the goalposts seem to have moved slightly. Equally, it shouldn't be overlooked that this is quite an extreme case. There was only the one English office, and the individual was doing all of her work for that office and returned to work on occasions, and it looks like it was more than 2 weeks in every year, in that office in connection with her work. This brings me on to the second aspect of the case. I think if you're setting up these arrangements, the case is a really useful one to bear in mind. For example, if there is more than one company in the employer's group, do you wish to move the contract to employment so even if the terms don't change, the contract itself is no longer with the English employer? Do you wish to change the choice of law clause in the contract? You may also wish to ensure the individual does not report into line management based in Great Britain. One point to bear in mind is the judge in this case did suggest that it was a relevant factor the individual did not have a claim in Australia. In the recent case of Credit Sites and Dunner, however, the Court of Appeal, I think it was, were very clear that it was not necessary to take into account the existence or otherwise of claims in the competing jurisdiction for the employee. We looked at that back in podcast 56. So I think on just that one small point, the AT decision here may need to be treated with a little bit of caution. Some years ago, we ran a competition on this podcast for songs for employment lawyers, and it was back in December 2012, for those of you who are minded to search it out. Anyway, I think we have our first entry for 2015 for the equivalent song cycle for employment lawyers, and I'd suggest that at some point you're going to be seeing an article written on this case under the heading of It's All About the Bass. Sorry. Anyway, that's the case of Mrs. Lodge and dignity and choice in dying and compassion in dying. Finally, I promised I'd say a few words about the additional rollout of the podcast. When we started doing the podcast, the idea was that it would be audio only, and typically would be listened to people on smartphones, etc., often while commuting. One of the oddities of doing the podcast is that generally and genuinely we don't know who listens to it unless they get in touch with us, which, by the way, please do. And I'm always interested to know who listens to us and what our listener profile is. However, a couple of people have asked about rolling out the podcast on YouTube. And I've also noticed that there are some updates starting to be put out on YouTube by employment lawyers. I'm not sure we need to make the move to a video feed just yet. Let's face it, footage of me sitting in a small room, talking into a microphone and waving my arms around may not make the most riveting television. But instead, we're going to make the audio recording available on YouTube as an alternative way of listening to the podcast series and see whether that takes off. Again, any feedback on that as an idea would be welcome. Equally, if there are other ways where it would be helpful to have the podcast transmitted, please let us know. So, all that remains for me to say is thank you very much indeed for listening, and look forward to speaking to you on podcast number 64.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.